Thank you, everybody, for joining. Really appreciate it. I know everybody's busy, and what we're doing here is Harry Barth is our founder at Barth Calderon, and we want to just relay the hot topics, hot issues, Harry, that you're seeing right now. Obviously, a lot going on in the market
Yeah,
of
you bet.
asset protection and estate planning. So with that, Harry, let's jump into it. And I know you got a few hot items to cover.
We want to make sure that we record this, Paul, so we have it for.
Got it. We're good.
Got it. Well, good morning, everybody, and thanks for joining us this morning. I'm excited to let you know about some interesting and very, very current things that we are seeing that I think impact each and every one of us individually as well as professionally. First thing I want to talk about is something which I almost fell out of my chair out. And surprisingly, it came up very stealth through the California legislature. 3 weeks ago, was signed into law and takes effect on January 1st of 2021. And what's that? Well, it's about the California homestead exemption for all of our clients and each and every one of us. We've made a gigantic leap. So what was the homestead exemption in California? And it still is until the end of the year. Now, in California, if you owned a home, your primary residence, and you were a single owner of that property, $75,000 of equity was protected from the claims of creditors. If two or more people occupied the home, married couple, for example, it was $100,000 of equity. And if we had a person over age 65 or a low-income person or a person who was disabled, who was in the house, that exemption amount increased to $175,000. So those were the dollar caps, and they were classified based upon classifications. So practically overnight, with a signature of Gavin Newsom, just hard to believe, that has all changed. So effective January 1st, let me give you the new California homestead exemptions for every one of us. And now there's no longer a classification system based upon status. So we have a minimum of a $300,000 homestead exemption and a maximum of $600,000 homestead exemption. And that homestead exemption is guaranteed to be adjusted by inflation or price increases on January 1st of each year. So with one signature of a pen, California went from one of the worst homestead exemptions to one of the best homestead exemptions, to the fourth best homestead exemption in America.
And Harry, this is just on your primary residence, not a rental.
Only on your primary residence. And the difference between the 300,000 and the 600,000 is where the home is located. So although it's new and we don't know exactly, they're saying that if the median home price in the county where the home is located is 600,000, then you'll have a $600,000 homestead exemption. If it's 300,000, 300,000, 400,000, 400,000. For most of us in Southern California and in Northern California, it's over the $600,000. So we all have a $600,000 exemption. This is a very, very, very big deal for ourselves and our clients in California. And since California has opted out of the federal bankruptcy laws, and we have our own, which are binding upon California citizens, that $600,000 is also a bankruptcy exemption. So, which would give us a tremendous amount of planning opportunities and paying down mortgages or increasing mortgages to keep that $600,000 parameter available. So that's exciting and good news for residents that own homes in the state of California. And it does affect a lot of asset protection planning. Because now if someone's got a $600,000 mortgage and a $600,000 exemption, that house is an exempt asset at up to 1.2 million, maybe even 1.2 million 50,000, because we have a $50,000 cost in selling or disposing of a property. So I wanted to bring that to everyone's attention. I think that that's really important. Of course, it wouldn't be complete to share with all of my colleagues here if we didn't talk a little bit about COVID-19. Now, COVID-19, I'm not going to talk about it from an infectious disease point of view, but I'm going to talk about it from a liability point of view. as if we didn't have enough liabilities as homeowners and driving cars and owning businesses and doing the things that cause us to, all of us, that we should be making sure that we've analyzed our financial situations and those of our clients to make sure that we've taken advantage of every single asset protection opportunity. We have some new ones. Let me share with you what they are. And one of the, I guess, the extremely negative issues is that in any of the state and or federal stimulus packages, or maybe one yet to come, at least so far, what we haven't seen is any legislation which relieves liability. And that's a peculiar and particular problem. So what have we been seeing and already emerging in the area of lawsuits? So one of them that we see is for an employer, failure to provide a safe work environment for their employees, and for retail stores and stores or where people come on the premises, failure to provide a safe place for consumers along the way. And so what happens here is that in California, we have a presumption that if someone has COVID-19, that it was contracted, in the workplace, and that they're saying it would be a workman's compensation claim. However, when that person now goes home, God forbid, infects grandma dies, we're now beginning to see lawsuits against the employer, both individually and from a business perspective, for the wrongful death of grandma. Whether or not that will prevail or not, we have a long way to go. This is all Genesis type of litigation, but it's litigation. We don't even know if it's going to be covered by insurance, not covered by insurance, but it's a horrible scenario. And again, a reason why we should have both businesses and personal asset protection at their apex at this time. Now, some of the other things that we're seeing as far as litigation is concerned from COVID is improper product advertising and pricing. So, spray this stuff and it kills 99% of viruses, and, $15 for a pack of toilet paper. So you got price gouging, which is going to bring litigation, improper advertising, going to bring litigation. Just another one that we're seeing. We're also seeing this one, and this is the inability for a business or a service to perform because of COVID-19, saying we can't do it because of the virus, and then being sued. And then the question is what they call force majeure. Is this an act of nature that rises to the level that relieves people of contract liability? That's going to get litigated. The early, very, very early decisions are that so far this is not force majeure as defined by insurance companies, and will lead us to further litigation.
Harry, does that relate at all to the rental property business? And
yeah, I'm going to get right to the rental property business. So the rental property business, as one thing, and failure to provide services that were contracted for. So you got two things. People contracted for various different services, for weddings, for this, for that, various different contracts, and they just don't provide the services, saying COVID-19, relieve this of the liability to do that. And then with the rental, we have the California kind of eviction prohibition going on right now, but the eviction prohibition is not a relief of rent. So let me give you an example. I did a presentation a couple weeks ago to 50 franchisees from the Massage Envy Franchise Association, and they were shut down. And as a result of being shut down, some of them had 5, 7, 8, 9, 10 locations. They were unable to provide service. They were unable to pay rent. So although right now, under law, they can't, there's still no question of how that's going to be resolved. Almost all of them universally had personal guarantees on the leases. So even though the business may not be able to do it, and you maybe even put the business in bankruptcy as a result of this, which is horrible, there's their personal guarantee. They could lose their home, their savings accounts, their rental properties, all their personal assets that are not properly planned for can be lost as a result of this pandemic. And we still don't have on the horizon any legislative relief with that. Then we also have, failure for people to provide refunds for when they've taken money for gym memberships and other types of things, and the gym is closed, and they're still getting the credit card and they're not making a return on that. We see class actions coming in that way against the gyms, the gym owners. So COVID-19 has created its own unique set of liabilities on top of the already existing litigious environment that we have in California. Now, while I'm still on that subject, let's talk a little bit about something that we have in California that's relatively not well known, that we all should take a second look at. So California has not been known, as we know, as a state that has been an asset protection friendly state. But California has always been known as a state that is very, very pro-employee, very, very pro-retirement. Matter of fact, when we look at a retirement plan, or most retirement plans, with the exception of traditional IRAs in California, they are all exempt from the claims of creditors. And we have one of the better secondary, I think it's primary, but secondary considerations in a retirement plan, in that if in California, the tree is an exempt asset. So if the $900,000 we have in our retirement plan isn't considered an exempt asset under California law, then distributions from that tree to us are also considered to be exempt assets, as long as we can trace them back to the tree. Now, in most states, when we take assets out of a protected environment, they would be subject to the claims of a creditor. And also in many states who consider distributions from retirement plans to be deferred wages, they are subject to the wage garnishment laws, which can range up to 25% of each payment being collected by the potential creditor. In California, it doesn't matter. So we took $700,000, we paid our tax, and then bought a boat with the money that we took out of our retirement plan. We can call it the HMS, retirement plan. That boat could be considered to be an exempt asset if we could trace its source of its purchase back to the retirement plan. So that's pretty good, but it gets a little bit better. But please understand that the next component that I'm about to describe to you is a California only exemption. So if somebody is living in, started this particular program in California, moves to Nevada, Oregon, Washington, or any other state, all bets are off. So this is exclusively only for California. So in California, back in the early 70s, when they were long before there was ERISA, they were putting together exemptions to protect retirement funds in California. It's very important to California as a state culturally to protect employees' retirement plans. And they came up with the legislature defined a section called 704.115 of the code that is both a state creditor exemption and a bankruptcy exemption in California for what we call a private retirement plan. So they said a private retirement plan is an exempt asset. And the legislature believed it early since the 70s and has never modified it since. That was the only direction that they came up with. So over the years, the definition of what a private retirement plan in California has been defined by the courts and through court cases. But here is the end result. It's a non-qualified plan, so it could be discriminatory. Company could set one up for Paul, for example, or for the owner, and we would define how much retirement we'd want to have at a specified retirement age, and we would be able to now to transfer. So let's say we wanted to have $60,000 or $100,000 a year benefit at 65, and they're 45 years old. That might require $2.5 million worth of contributions to this plan. So literally, we can put $1 million worth of stocks, bonds, and cash, maybe an LLC that owns real estate, and or even a portion of our business into this retirement plan. Since this retirement plan is after taxes, there are no tax ramifications. Nothing. It's like a grantor trust. You would still pay your taxes on that, but the ownership would shift to the private retirement plan. And if that was construed to be a retirement plan, which we'll talk about, it's a completely exempt. That $3 million worth of assets are completely exempt from the claims of creditors in California. And if the tree is exempt, the fruit of the tree is exempt. So it is probably one of the best asset protection tools available to anyone in the country, and exists right here in the good old state of California. Now, it's not, the courts have said inherently just because the retirement plan provides asset protection, that's okay, but it has to be a retirement plan. So we have to have an actuarial determination of how much is it for retirement. We need to determine an interest rate. We need to determine how much we can set aside today and how much we can add to it over a period of time. We need to have an independent third-party administrator. We have to have an independent trustee and a plan document. It is a retirement plan. It's not money that we take in and out, but however, we can borrow money from our retirement plan just like we could from any other defined benefit plan with proper security and proper payments. So as long as it looks like a retirement plan, smells like a retirement plan, and acts like a retirement plan, that bundle of assets, as long as they're a resident of California, remain completely exempt from the claims of creditors and distributions from that plan. This is, and since it's a bankruptcy exemption, we have a tremendous amount of liberality in the way it can be construed. I'm pretty excited about that. Our firm has set up quite a few private retirement plans, and I think that our clients need to understand the power of that and how much it can be used. Now, that is another asset protection tool, but I want to move over to another specific area that's swirling all over the place right now, and that has to do with estate taxes and estate tax exemptions. This is a big one, and the last one that we'll be talking about today for your lexicon to note and to write things down. So here we are, a couple days after election. And we're not going to be talking about politics. I think politics does not belong within the lexicon of what we're talking about today. But we're going to talk about, as Trump has said and others, elections have consequences. And the consequences of this election in the estate tax arena are potentially significant, especially dependent upon what happens with the Senate. So let's talk about what that issue is. And this is a multi-million-dollar issue for many of us, ourselves personally, and for our clients. We're not going to go through an exhaustive study today of the ways in which to deal with it, but I want to make sure every one of you are aware of the problems and the time limitations that we have to help our clients and help ourselves in this area. So when Donald Trump and team came into office and exhibited tax reform 2017, 2018, one of the centerpieces of the tax legislation was a significant increase in the amount of assets that can be transferred from parents to children or to others. Call it a transfer tax, not a state tax, because we tax the transfer from what was at that point $10 million by a married couple, or $5 million apiece, up to $23 million indexed for inflation, which was significant, and knocked out about 90% of the estates in America would no longer be subject to transfer tax. So this was considered obviously a benefit for the rich, and the rate of transfer tax above the 23 million was 40%. So we had to pay the king 40% to transfer everything above 23 million to our next generation, which unto itself is confiscatory. The whole tax sucks, but it is what it is. Because at that time, we did not have a filibuster-proof Senate. They were not able to change the law permanently, whatever permanently means in Congress, because they could change it at a moment's notice based upon political indications, but they didn't have enough votes to make it permanent. So they had to go under what they call the Omnibus Budget Reconciliation Act, because they couldn't get 60 senators. They got like 51, 52. And tax law changes on the Omnibus Reconciliation Act could go out no more than 10 some odd years. In this particular case, they said on December 31st, 2025, absent new legislation from Congress signed by the president, the $23 million exemption automatically returns to the 2017 rate of a $10 million exemption, exposing $13 million to a 40% transfer tax, round numbers, $5 million. So maybe more than that, six and a half, yeah, about $6.5 million of taxation on that $13 million. That is a lot of money. And that is automatic. So absent having the White House and Congress as one party to make modifications and changes, which we probably won't have, we are returning to that level December 31st, 2025, January 1st, 2026, gone. Second, Biden victory. So what has Biden done? I would just say Democratic victory, doesn't matter. They have put out their proposal for transfer taxes. Their transfer tax proposal takes the $23 million exemption and returns it to what they call the historic norms, which is absolute propaganda. And that is $3 million a person or $6 million for a couple. So we now go from 23 million to 6 million, exposing $17 million to transfer taxes that we do not have now. And the changing of the rate from 40% to 50% and graduating up depending upon the size of the estate. So for easy math, if we use 50%, that means, well, at 17 million, and I can do the math, I think that's $8.5 million worth of taxes that would be subject to tax that we do not have now. And so that leaves people with a dilemma. So the dilemma, however, can be mitigated to a great degree with some fast, quick, decisive, expert action this year. So although it's a little late, it probably still possibly can happen. There are tools and techniques that we have available that allows us to transfer assets between spouses and children. I mean, so Harry can set up what we call a spousal lifetime access trust for my wife and children, transfer my $11.5 million to that trust. My wife can get access to it on behalf of the family and behalf of the children. So I kind of have my cake and eat it too. And by filing an appropriate gift tax return next year, I'm able to secure that $11.5 million exemption. And we have assurances from the IRS that if we take advantage of the laws that we have in place now, should those laws change, that we would keep that 11.5 million. So, and we can do that for both spouses. There's some rules on non-reciprocity that we have to look at, but we can basically $20 to $23 million, or somewhat less, 6 million, 5 million, 4 million. We can make sure that we use up a good amount of our exemption amount while the going is good. And I think that although it's been publicized, in Forbes and other places, I don't think clients really recognize that. And what we're going to get is we're going to get a waterfall. We're already seeing it, of clients looking to use up their exemptions, especially should Mr. Biden hit 270 votes. So I think that you need to know that, be aware of that, know that there are tools and techniques, and to not let our clients and ourselves know that borders on being criminal, because they look back and say, hey, why don't we do that? We have sent out as a firm to everybody at least 2 or 3 blasts, Paul, letting everybody know we have this opportunity. We started in July, and of course everyone's going to wait till after determination of the election. This happened in 2012 as well, and I think that is it's just we may not be able to accommodate everybody, and millions of dollars, literally millions of dollars within families can be lost. We can gift, or transfer some parts of small, closely held businesses. The difficulty is appraisals. It's hard to get appraisals at this time of the year. I spoke to some head appraisers yesterday from top appraisal companies, and basically we've come to the conclusion, we pick a number. We pick a number this year because we're not going to be able to get an appraisal done. Most of our clients, if they're not greedy and use an objective look, have a very good idea of what their assets are actually really worth. And then next year, we could finally wind up getting all the formal appraisals. And if it's early enough in the year, we could take the opportunity to make some adjustments to the tools that we use to bring those values within the values that the certified appraiser would have come up with. So we do have the opportunity to do that. I think that we should take advantage of that. And
Harry,
one thing,
Harry,
just
quick,
one
how does
second,
that?
Paul.
Yeah.
One second, Paul. And one thing before I lose it, I forgot to mention about the private retirement plan. Just setting back for a second is that all legal fees, trustee fees, third-party administrative fees that one pays to establish a private retirement plan in California, which is really exciting. I've established one for myself, or the firm has established one for me, is a complete tax deduction because of setting up a retirement plan. Yes, Paul?
Yeah, I was just going to ask you, how does the analysis start for the tax situation? I mean, you do initially kind of look at all the moving pieces?
Yeah, it's kind of challenging. A little bit of the process that we have is that first we have to describe, what the tools are to a potential client. For those that are not, doctors, lawyers, Indian chiefs, sometimes that's a little challenging to understand gift concepts. Then we need to explain the pros and the cons of a spousal lifetime access trust. Um, it's irrevocable, the transmutation of property. And for Mr. Patel, I know who's on the line, it's a grantor trust. Um, we have to describe that, and the client has to understand that. Then we need to identify the assets that would be transferred. One trust, two trusts, what percentage, up to what amount. Then we have to try to come up with some value for that which we've transferred, so we're within the applicable limitations. Then we need to actually make the transfers, open up any bank accounts that need to be done, and we have to get that done before the end of the year. And we could do it. And then next year, gift tax returns need to be filed and we can put those on extension if needed. Gift tax returns need to be filed to secure those exemptions for 2020. How exciting it is when a family realizes that we've saved anywhere from $4 to $8 million worth of transfer taxes, and actually it's quite larger than that, because although I may transfer $10 million today from myself to my wife and children in the spousal trust, that $10 million is completely asset protected from the claims of third-party creditors, both myself and my spouse. And all of the growth on that $10 million. So if that grows to be 20 million or 25 million, no matter who the president is, no matter what the estate tax laws are, no matter what the estate tax rate is going to be exempt from federal transfer taxes. What a wonderful, wonderful opportunity. So I want to make sure that all of my colleagues had at least a working knowledge of that, so we can help the people there. And that's about what I have to share with everybody this morning, Paul. And what do you say? What do you have that you'd like to add?
Yeah, no, I mean, I think it's all good. It seems like time is of the essence for some of this planning towards the end of the year here. And, with the transfer tax, property again comes into play there,
Yeah.
transferring property.
Yes. Yeah. And to the best of our knowledge, uh, with what's happened with Prop 15 and perhaps in Prop 19, we should be able to do all of that without any reassessment of the property taxes from the appraiser's office, so the assessor's office. So we should be okay. So I really don't want to take up everybody's time. I'm going to
Right.
try to do these updates and briefs for all of our colleagues more frequently. And I really appreciate it, and I appreciate everybody who joined us this morning. And so, Paul, if there's no further questions from you, we're going to call it a day.